Good morning, everyone. Thank you, Mr. Rao, for that technical discussion on IPR. I think that was very helpful. And I'm really glad to be a part of the panel because the way we've structured is that the first session was on the technical aspects. What I would cover is basically the valuation and the commercial aspect of IPR. What are different valuation approaches that are applicable? And we finally have Greg, who will talk about the practical and legal aspects of the IPR. So very quickly, let me briefly introduce myself. I'm a director in Ernst & Young. I specialize in quantification of damages, claims, and losses in case of disputes, litigations, and arbitration scenario, especially in case of intellectual property disputes. So with that background, we move on to the presentation. This is kind of an overall summary of what we would cover today. What are the trigger for IPR disputes in India and globally? What are different valuation approaches and methodologies that are applicable, which are classified primarily into three: an income-based approach, a market-based approach, and a cost-based approach. And within each of these approaches, there are different methods that can be applied depending on what kind and type of intellectual property we're dealing with. Finally, what are different heads of claims that we notice in case of arbitrations or litigation where IPR is involved? That's the section which talks about claiming lost profits as damages, or computation of royalty rates or price erosion damages. I'll cover the trigger for IPR disputes very quickly over here. So what is really the trigger that I'll give you a live example of a legal versus economic owner of a brand or a trademark or a patent. Typically what we've seen in India, what we've observed is that the technology owner, the legal owner of a technology or a patent is sitting somewhere in one of the global companies. Now that technology is licensed to one of the Indian companies. Over time, over a decade, when the technology is exploited, it generates huge revenues. It becomes a big brand. It becomes a big trademark. The commercial exploitation of that technology, which happens in India, the Indian company pays a royalty rate or a charge for the use of technology to the legal owner. What we've seen is over time, there are disagreements between the legal owner and the economic owner of that patent or technology. Because the question comes, who really owns it? Is it the person that invented the technology, legally owns it, the global parent company? Or is it the Indian company which has actually exploited that, sold it, used it, commercialized it, and over the past decade has brought to a level that it has become huge and significant today? So these kind of disagreements or disputes arise from the commercial exploitation of that patent. The second evidence could be a disagreement over the royalty rate itself. So for example, if there is a 3% royalty rate which has been agreed that the Indian company would be paying to a foreign company or a parent company, that 3% royalty rate in today's world, after the commercial exploitation for a period of 10 years, may not appear to be reasonable. So there's a disagreement over the rate itself. And of course, if there is an infringement which has happened, suppose there is a technology or there is a trademark which has been copied by somebody in India, and they are selling off the fake products or counterfeit products. In that case, the claimant would put a claim for infringement of its own brand name or a copyright or a design. So where we come into the picture is that we help the claimants prove and establish that this will be the total quantum of damages that they can bring into the picture in the entire lawsuit, and that can be divided into several heads, which I've discussed in the slide below, that you can either claim the lost profits as damages, basically the entire profits or sales that are made by the respondent, the profit margin that you will generate over the sales made by the respondent using the infringed trademark can be claimed as one of the heads. Or you claim a royalty rate over the use of that technology. And in some cases, you can also claim price erosion damages. So we'll cover that in detail in the next slides. Claiming lost profits as damages. In this scenario, the most pertinent aspect is the period of infringement. And of course, this happens in discussion with the legal advisors. So the entire quantification of damages part is always done in line with what is the legal view, which comes, of course, with the legal advisors. And the second is the company management, the technical experts. As Dr. Rao mentioned, that the entire R&D, the entire merit behind how that patent or the technology or the brand got generated is equally important. So once the period of infringement is established based on relevant evidences, correspondences, or supporting documents, what is essential to establish is that during that period of infringement, what is the total quantum of sales that were made by the respondent company using the infringed technology or the infringed copyright or the brand. And this can be done either based on the financial statements of the respondent, which may not be available in public domain. If they are available in public domain, that becomes a strong evidence that during, say, last 2 years or 3 years, which is the infringement period, the company has made X amount of sales. If such information is not available, how do we then arrive at the quantum of damages? It becomes challenging. It becomes a subjective exercise. But what we've seen is that you can create different scenarios. So based on whatever limited market information you have, the brochures that the infringed products talk about, we create different scenarios with respect to the number of units that could be sold. And under different scenarios, there will be a range of the quantum of damages that we could arrive at. And the final step is the profit margin of the claimant. Once you arrive at this quantum of sales of the respondent company, what you are claiming really is not the loss of revenue. You're claiming is the loss of profits that you made on the sales which the respondent made using your technology or your patent or brand. So the claimant's profit margin, which may be healthier or significantly higher than the respondent's profit margin, the claimant's profit margin are applied on the quantum of sales made by the respondent, and this becomes as one of the head of damages, which is lost profits as damages. There is a Panduit test, which I'm sure many of you would have heard. It's a case law. It's a precedence which is typically used in order to prove that entire sales of the respondent can be claimed as lost profits by the claimant. So what this case law says is there are 4 conditions, and if these 4 conditions can be applied in my client's scenario, then 100% of the sales made by the respondent can be claimed as lost profits. What are those 4 conditions? That there is demand for the claimant's product in the market. Claimant has the manufacturing and marketing capacity to cater to that demand. It is not just sufficient that claimant has a demand for the product, but if the claimant company does not have enough capacity to meet that demand, then you cannot claim this head of damage. Third, there are no non-infringing substitutes available in the market. This is very critical. If there are substitutes that are available in the market, this will affect the overall market positioning and demand for the claimant's product, which is condition number 3. And of course, there should be a reasonable benchmark available to establish the amount of profit that the claimant would have made. So these are generally the 4 conditions that are mentioned whenever a precedence is given to the Panduit test. Computation of royalty rates. Royalty rate, as I defined earlier, is a reasonable rate typically expressed as a % of sales below which any award of damages should not fall. So I give you an example of a foreign Indian company where the Indian company would pay a % of its sales that it made using the technology or the IPR that is legally owned by the foreign company. So in return, they would pay a percent, say 3% or 5% to the parent company of the total sales made. Now, in a dispute or an arbitration scenario, the question comes whether that royalty rate is fair, reasonable, and non-discriminatory, or FRAND as we call it. In order to compute royalty rates which are fair, reasonable, and non-discriminatory, again we use certain precedents which are called the Georgia-Pacific factors. This is again a case law. It's available in public domain. You can make a reference to that. It talks about 15 different criteria or qualitative factors that one must consider while arriving at a reasonable royalty rate in case of any technology or patent. These Georgia-Pacific factors serve as a starting point for determining the reasonable royalty, and they're influenced to a large degree by the presence or absence of substitute either on the demand or supply side. Okay? Price erosion damages. Price erosion damages simply means that if the claimant is a significant brand and its products are selling at a very high price in the market, because its products are infringed, that brand is infringed, the respondent sells those products at a cheaper rate. Because of the respondent using that infringed technology or the brand selling products at a cheaper rate, the price at which the claimant eventually ends up selling its own products gets reduced. Because there is competition in the market, there is a cheaper substitute available, he has to reduce that price. Therefore, in order to establish price erosion, what the patent holder has to prove is the amount of profits that patent holder would have made by selling its